yeah, I see Jeff.
Number one student in our class.
Do you know Keith Gill? He's here.
Okay, well, thank you for coming out. It looks like somebody might have told some of you that we were having a Duke basketball game here. I mean, this is a pretty spectacular turnout for a program, and particularly on Saturday morning before lunch. But we're very happy to see all of you here. We have just a first-rate panel to talk about these issues relating to sports and universities. This is a very interesting time for college athletics. A lot of issues confronting universities and the athletic programs, and we're going to talk about some of those. We have only an hour, so I'm going to make a very brief introduction of our panelists, and then we're going to start right away. Our hope is that we're going to have, well, actually not our hope, we're going to have sufficient time at the conclusion of brief presentations to take questions from you, to see what it is that you're concerned about, and to get the reaction of our panelists. So let me introduce them very quickly. Except for Paul Haagen and myself, all of these are at least double Dukies, and one is a triple Dukie, so they are very familiar with the university. Jay Bilas, you all know, I'm sure, is a double Dukie, graduated from the law school. He's an ESPN college basketball analyst, one of the best, and is of counsel to the Charlotte law firm of Moore and Van Allen. This is a truncated introduction. I assure you that they have pages of accomplishments. So
all of which we'll read to you later if you're.
We'll see how many of you come out for that.
That was going to be my presentation.
Robin Harris, who is also a double Dukie, Law 93. She's the executive director of the Ivy League. She'll tell you what that is. Gabe Feldman is an associate professor of law and the director of the Tulane sports law program and the associate provost for Tulane for NCAA compliance, a very big job. And then Paul Haagen, whom you know, he's a professor of law here and co-director of the Center for Sports Law and Policy. So what we're going to talk about is some of the issues that are confronting college athletics today, some of which could be game changers in a real sense. And we had a very interesting discussion before coming up here. Michael Dockerman told us not to leave it all on the practice field. So we cut it off, and here we are. We're going to start with Paul, who is going to sort of do the setup for this discussion and provide the context in which some of these issues are going to be discussed.
I'm going to start with a historical perspective on this, and it was just under a century ago, in 1905, that President Roosevelt called the great football powers of the United States, Yale, Harvard, and Princeton, to the White House to try to address a crisis of legitimacy in the sport. An unacceptable number of football players were being maimed and killed, and the sport appeared to be encouraging forms of brutality inconsistent with the values and norms of higher education. Things came to a head at the Harvard-Yale football game in 1905. Yale punted the ball to Harvard, and Francis Burr attempted unsuccessfully to field it. According to the New York Times, he was unsuccessful because as the ball was fluttering down, Jim Quill from Yale punched him in the face, and an unnamed Yale player delivered a flying kick to his midsection, rendering him unconscious and unable to continue. Now, Yale denied that there had been rough play, and no foul was called. And no foul was called because those were not fouls. Gentlemen, of course, would not do such things, but the social conventions regulating sporting behavior were breaking down, and that breakdown demanded some sort of a response. Now, we are in one of those periods in which social consensus around intercollegiate sports is once again breaking down, and we are seeing increasingly strident demands for new terms of competition that will restore legitimacy to the exercise. Now, the response in 1905-6 was a comprehensive and increasingly intrusive form of regulation, and it's the form of regulation we see today. There are now suggestions that we have new forms of legal or other forms of regulation to replace this. Some of them, I think, are interesting at a time when unionization of labor is being abandoned right across the country. We just saw the auto workers in Tennessee reject collective bargaining. We're getting the demand for the unionization of intercollegiate athletes. And what I am hoping today we're going to get from this really quite extraordinary group of Duke-trained lawyers, all of whom pointed out that they were not trained by either Jim or me, which is perhaps why they're extraordinary. But as they think through what are the appropriate legal responses that will help us restore legitimacy, a sense of social legitimacy, and an effective set of controls for sport, which is built around controlled competition.
So Robin is going to address the mission of college athletics and more specifically the education of college athletes.
Thanks. So back when I was in Duke Law School and I was working on my law review article, which was sports related, on the Jerry Tarkanian case that went to the Supreme Court, and I was assessing whether the Supreme Court had decided the NCAA was not a state actor and did not have to provide due process in the enforcement procedures. So I wanted to analyze whether or not they, in fact, did provide due process. And thereupon, I embarked upon a journey that I'm still going. And it has led me to my career, truly, because I learned so much about the NCAA process. I did, in fact, conclude that the NCAA generally provided due process throughout the enforcement procedures, except in a couple of areas where there was good basis to not provide open hearings or cross-examination of witnesses. But it was interesting because that led me to reading a multitude of cases that had been in the courts about the NCAA process and the amateurism status of the NCAA and the fact that participating in college athletics is not a right, it's not a right, it's a privilege. And those are legal terminologies that really were helped form my philosophy on how we approach this endeavor, which is collegiate athletics. And courts have, over time, upheld NCAA restrictions as being pro-competitive because of the overall stature of athletics as being part of the educational experience of the student athletes. And so you really have to look at what is the mission of intercollegiate athletics. Now, the money today is so much greater than it was 20 plus years ago when I was doing my law review research. But the fundamentals for 98% of what we're about is exactly the same. That the vast majority of sports, we're not talking about the same revenue that we're talking about in a small minority of football programs. About 65 football programs are generating the revenues that create the headlines. And in basketball, it is most of Division I. It is an overall enterprise that generates revenue. But it needs to be tied to the educational model. Have we lost our way in some aspects? Yes, I think we have. Is the money to a point that it's become a barometer for criticism and a lightning rod? Yes, absolutely. Can we put the genie back in the bottle and go back to where the money is not such a lightning rod? Probably not. So now we have to figure out where we are and what changes do we want to talk about. The fact that student athletes devote a lot of time to their sports is it's self-generated by the student athletes often. It's also generated by the coach and the expectations, and it's generated by their teammates as well. And so in the Ivy League, for example, where we put more limitations on student athlete time demands than what the NCAA allows at Division I, we still have student athletes conducting captains practices, which are sometimes against our rules. Sometimes they're not. And we can't lock them in their rooms, though. So the fact is, when you have individuals that want to compete at the highest level, they, in fact, want to play. They also want to do it, I think the majority, want to do it as part of their educational experience. And in fact, the NCAA used to have a tagline, which I don't know why they dropped, because I think it's true. And it's that most of the student athletes are going pro in something other than sports. We are truly preparing individuals for success in life through an educational experience in the classroom, but also on the playing fields and the courts. And in doing so, what is the value that's being brought to the universities? Well, it's a sense of campus community. How often do you run into Duke alums who want to immediately talk about the success of the basketball team or the football team or the lacrosse team? It's a tremendous bonding experience for the community, and it makes me proud to be associated with a university that I think does it the right way, that is integrating athletics with the campus environment. Have things changed over the past couple of decades? Absolutely, but they've been regularly changing in the past 100 years with intercollegiate athletics. So it becomes harder to justify. It used to be easier to say, well, the student athletes are getting an education at a place like Duke that's worth a couple of $100,000 just in terms of the educational cost, and they're getting the benefits of a wonderful education. Well, as coaches are making millions of dollars, it's harder to balance that and to say your education worth a couple of $100,000 is comparable to what your coaches are getting or the school's getting as they bring in the millions. But for most of our student athletes, that is true. It's still a true comparison. They are getting, if they're taking advantage of the educational opportunities provided, they are really able to go on and succeed in life through what they've learned in the classroom as well as on the playing fields. Now, we have issues. There's no question about it. The NBA has a rule that it's a collective bargaining rule with one and dones. And so we have situations where players are being forced to come to college if they want to have a professional career. They don't have another good option. They could go to the NBA Developmental League, they could go to Europe, but generally we are forcing people, some of whom I hope become students, but not all do, right? So they come and they have to come for 1 year and they have to stay eligible that first semester, and then they don't have to be eligible the second semester. They don't even have to go to class, really. Now, the school pays a penalty. There's a metric that measures that, but they can overcome that if they manage the numbers and have enough other players to maintain their eligibility. So I think that's a problem. That's not a problem of the NCAA's doing, and I don't fault the student athletes either. I think they're doing what they have to do. Baseball, interestingly, baseball has a model where you can get drafted right out of high school, but once you go to college, you can't get drafted for 3 years. Baseball has the highest number of NCAA players who go on to a professional career. That may be because they also have a legitimate minor league system, but about 9% of NCAA players go on to a major league career. It's 1% in football and basketball. So what we're really doing is spending the majority of our time and energy dealing with these very challenging issues, talking about a couple of percentage of our student athletes, when I would tell you the overall enterprise is still very legitimately part of the collegiate environment at the Division I level, and certainly if you look at the other two divisions. We have over 1,000 NCAA member schools, and then you have NAIA schools that sponsor athletics as well. So, and the sense of community really shouldn't be lost. And the revenue that is generated does go back to support other sports. So you have a school like Duke, and where they've just announced an initiative to add softball and to fully fund other programs like rowing, and I think that's tremendous, and Duke should be recognized. There are other Division I programs that are basically at the bare minimum of NCAA sports because they're putting their money into football and basketball. And I think we should look at those programs that, if you believe in our model and you believe in the collegiate athletic experience, then you should believe in it for a wide variety of sports and not just a handful.
Thank you. So Gabe is going to talk about some of the litigation challenges that are confronting the NC2A and college athletics.
Okay, thanks, Jim. And I think this is going to be a slight detour from what Robin just said, and I think Jay will then probably join the issue with Robin. It seemed like Jay was having trouble controlling himself and not responding immediately.
Because I was trying to block out a little.
So pardon the legal interruption here, but let me just spend a few minutes giving an overview of the litigation facing the NCAA. And there was a quote Mark Emmert gave, the president of the NCAA, I think it was last week, where he said, if we're not getting sued, the NCAA, we're not doing anything. And what's clear is that they're doing a lot.
I'm not sure I agree with Mark on that point.
At last count, I think there were about 20 different lawsuits facing the NCAA. I want to really focus on what I would consider the four big ones, and then the unionization effort, which is not technically a lawsuit. Let me start with the unionization effort. As we probably all know, the Northwestern college football players petitioned the NLRB to be recognized as employees so they could form a union and collectively bargain with Northwestern. And the regional director in Chicago ruled just recently that the scholarship college football players at Northwestern should be considered employees because, and this is going to be oversimplified, they provide valuable services to Northwestern for compensation and are within control of the coaches at Northwestern. And then by definition, they should be considered employees. Not surprisingly, Northwestern disagreed. They just recently filed a petition of appeal to the full National Labor Relations Board. The Northwestern college football players will vote to unionize or not unionize on April 25th. And the results of that vote will be kept secret until the full board rules on whether or not they should be declared employees or not. After that, what likely will happen is the case will be appealed either to district court in D.C. or district court in Illinois, and then up to either the 7th Circuit or D.C. Circuit, and then potentially all the way up to the Supreme Court. Potential. So that's hanging out there, obviously, as one potential leverage shifter. Then we've got the lawsuits that are facing the NCAA, the big lawsuits that are facing the NCAA. One is the concussion litigation, which hasn't really been discussed much lately. It in some ways mirrors the NFL litigation, concussion litigation. Some of the similar arguments have been made here. What's interesting about the NCAA concussion litigation, I think we've got now 71 plaintiffs out there, and 69 of them are football players, 2 are non-football players. But most of the 69 football players are football players who never played in the NFL, which was an attempt to say we don't have to prove that the damage occurred when we were playing college as opposed to the NFL because we never played in the NFL. What it looks like is that's most likely headed for settlement. I don't think that's what the NCAA has been talking about. It's what the plaintiffs' attorneys have been talking about. The bigger cases that may, in fact, not be headed for settlement and present potentially the bigger risk to the NCAA and the structure of the NCAA and the future of college sports in the 2% of college sports. We're talking about now big-time college basketball, big-time college football. We've got the O'Bannon litigation, which has been out there now for several years, which started as former student athletes, claiming that they were entitled to compensation for the use of their likeness in video games. and has since evolved or devolved, depending on your perspective, into all student athletes claiming that they're not only entitled to compensation for use of their name and likeness in video games, but also for use of their name and likeness in televised games. And what that lawsuit is now seeking is a share of television revenue. So these student athletes are now seeking a share of the billions of dollars that the NCAA and the conferences and the schools make from televising college football and college basketball games. If successful, and that claim is brought on both antitrust grounds and right of publicity grounds, if successful, that may not change anything about the way we view college sports, but it will shift revenue from where it is now in the hands of the administrators, the institutions, the schools, and shift at least some of it towards the student athletes. That's a potential ramification there, which again, shifting revenue, maybe not changing the way the sports are played, the way the sports look. The last two lawsuits, and the most recent lawsuits, are two antitrust suits filed. One by Sean Alston, who is a West Virginia running back, and the other filed by, and it's amazing, this is how it's referred to in popular press, filed by Jeff Kessler. I don't know how many lawsuits.
David Thayer, who's from Duke Law School.
Yes, but I don't know how many lawsuits are known by the attorney who's bringing the suit as opposed to the party in the suit. But for better or worse, it's the Jeff Kessler lawsuit. That is challenging the very basis of NCAA college athletics and the amateurism model. The challenge there is, in contrast to the way Robin just described college athletics, this view of college athletics is it's a billion-dollar industry where the product is defined by a vast price-fixing conspiracy. All of the institutions have gotten together and say, we refuse to pay whether they're employees, whether they're inputs, whether they're student athletes, whatever you want to call them, we refuse to pay them. We will not allow you to pay them more than a scholarship, more than whatever their grant and aid level is. The argument there is that that is clearly a price-fixing violation, that if any other industry tried to pull that off outside of a collective bargaining relationship, it would be probably per se illegal. Google and Apple are getting sued right now on a very similar type claim. That will be, if not held to be per se illegal, will held to be illegal as long as they can prove they're doing it. There's no question they're doing it. This is not an issue of proof. We have the agreement. We know what the agreement says. The question is that agreement legal? So we've got these four lawsuits, the unionization effort hanging out there, and the big question I think on a lot of people's minds is, will this actually cause any change? And people seem to think that we're at the tipping point. We're finally at the tipping point where we will see a revolutionary change in college sports. I'm not sure we're there, and I'll be quick. Do I still have time?
You're good.
Okay. I'm not sure we're there for two reasons. We may be there, but I just want to hit pause a little bit or pump the brakes a little bit for two reasons. One is we've been saying since probably 1906 that we're at the tipping point for college athletics. We didn't have the term tipping point in 1906, but if we had it, we'd be saying that. In 1929, in the Carnegie Report, the president of the Carnegie Foundation said that, and I'm paraphrasing, I'll say I'm quoting it because you don't know the quote, so it'll sound like it's exact, that the spur of commercialism in college athletics is eroding and threatening to destroy the educational and moral institution, something along those lines, in 1929. In 1984, and this is getting back to the Tarkanian case, we talk about all the criticism the NCAA takes now. In 1984, a federal judge compared the NCAA to the Ayatollah and Adolf Eichmann.
Both of whom objected to that.
So the criticism isn't new. The criticism isn't new. The question is, do we have enough leverage now on the side of the student athletes to actually force some change? So will these lawsuits provide that leverage? Will the courts look at it the way that I think many people, not all people, look at it, that we've got this billion-dollar industry where everybody's making money. Lots of people are making money, not everybody. A lot of people are making money except the student athletes, and there's an unfairness. And is that unfairness enough to change the way the law has operated? Because for decades, century, the courts have said the NCAA and the member institutions are allowed to pursue this noble goal of amateurism for the sake of amateurism. That these antitrust suits that have been brought in the past, the 1984, the Board of Regents case, established this precedent that NCAA, the institutions, do not have to pay student athletes because that defines them as amateurs. That defines the institution. That allows them to focus on education. Now we can say that is an old notion. Nobody believes in that anymore. And many people might believe that that's outdated and that the billions of dollars have infected the entire enterprise. And it's not about amateurism, it's not about educational ideals. We may think that's right, some people may disagree, but let me tell you what 4 courts very quickly have said on that issue. The Sixth Circuit and the Eighth Circuit, Sixth Circuit and the Third Circuit, in 1998 and 2008, looking at amateurism restrictions, didn't even look to see if that claim was still true, if amateurism was still a noble goal. Didn't look at the merits, just said that scholarships, payment to student athletes, is non-commercial. The Sherman Act does not apply at all. We have this billion-dollar commercialized industry. 2 circuit courts have said it's not commercial. No antitrust suit can be brought at all. 2013, the Seventh Circuit, which is where this NLRB appeal might end up, where the Northwestern appeal might end up, said it is still good law, amateurism is still a noble goal, even though we recognize that student athletes are receiving compensation in the form of a scholarship. They are paid, but because they're only being paid their cost of attendance, or not even quite their cost of attendance, we don't consider them to be paid. So they're paid, but they're not paid. And because they're not paid, they're amateurs, even though they are paid. But because they're not paid, they're amateurs. And because they're amateurs, antitrust law does not apply, and any rule that furthers amateurism is inherently legal. Inherently legal. Don't even have to analyze it under antitrust law. That was last year that the Seventh Circuit Court of Appeals said that. So we may be at the tipping point. We may be at the point where we say something's got to give. Might be there. Just want to throw a little hesitation into all this urgency and say we may not be there yet, and it may take more than just these legal threats to get us there. And then I think now, well, I'll turn it over to Jim, but to get to whether it's right or wrong, a very different issue. I'm just talking about the legal threats out there.
And Jay will be happy to discuss that. Whether we should wait to see what happens in the courts or whether the universities ought to move forward on their own.
My perspective, let me just give you a few things to think about. Are money and education mutually exclusive? And my contention is they are not. That no other student, in fact, no other person in a college setting is restricted. That every student at this university, at every university, can get their fair market value, except for an athlete. And this is a multi-billion-dollar business that we're talking about, college athletics. And the only person involved in that industry is subject to what I would call a cartel restriction that's industry-wide. And they are restricted to their expenses only. And one of the expenses is the expense of a scholarship that is paid to the school by the school. So really, the school is not out a nickel. The athletic department claims poverty when they're paying the school the scholarship amount. And I've joked about this, that if the NCAA, when I was in college, college athletics was just, back when it was just in the hundreds, revenues were in the hundreds of millions. Now they're in the billions. I think it's approximated $11 billion per year in revenues. The NCAA said, well, there's not enough money back then, when it's just the hundreds of millions. That's the same refrain you hear now. There's just not enough money to give to the athletes. So you could say that if the NCAA were in charge of the Sahara Desert, there wouldn't be enough sand. And it also assumes that this is a zero-sum game, that if the athletes were allowed more than a scholarship, then all of these sports would have to go away. And so basically what they say is everything teeters upon the athlete remaining amateur, that if we have to give the athlete more than a scholarship, or if we even have the opportunity to give more than a scholarship, sports are going to go away. We hear the doomsday scenarios. Sports are going to go away. You're going to see all these non-revenue sports go away. You are going to see this entire enterprise collapse under its own weight. And there's no basis for any of this. My contention is that these are already pro sports. And if we provide, if the NCAA talks all the time about permissive legislation, which makes it sound like the athletes are children that we're going to provide maybe a little increase in their allowance. And I don't look at it that way. I think the athletes have greater value than we allow. They have greater value than we admit. And to Robin's point about the community aspect of college athletics, I agree. There's wonderful community aspect. But that goes to the idea that the community is the ticket buying public, and we all gather here on campus and we talk about how great this is, and we get together and we say, hey, let's support all this stuff. It's terrific. Oh, Old State U. I don't think it really goes to selling the product to television, where the consumers of the product have no connection to the universities whatsoever, and they're just watching the competition. And that's where we are now. And that's why it's a multi-billion-dollar industry, is we've gone outside of this, of what we claim it has been. And now it's a commercial product. And it has been for a long time. I mean, the NCAA was founded in scandal in 1906. It's remained in scandal ever since. And most of the scandals are self-made by rules which I would argue don't make a whole lot of sense. I am of the belief that if the restrictions on providing athletes with more than a scholarship were taken away, and athletes could be treated like any other student and any other person, the world would remain firmly on its axis, and the business would be just fine. Right now, these athletes are not brought in from the they're not chosen among the student body and put on a team. They are brought from outside and recruited as athletes first. That's okay. Like when you see we just got off the NCAA tournament. I don't know how many of you watch the press conferences, but the press conferences are great. There's a moderator of the press conference. The coach sits next to the moderator, and then the players. And first up, they say, "Are there any questions for the student athletes?" And they always refer to them as the student athletes, and they get to be asked their questions first so that they can leave as if they're going to go to the library after that. But the constant term of student athlete is, it almost is offensive to me that I didn't look at myself when I sat on that podium 30 years ago answering questions as a student athlete. I was a player. Can't they just say questions for the players? And they can't. They won't. Because student athlete is a made-up term that the NCAA came up with years ago to try to avoid workers' compensation claims. And it's now become part of the lexicon, and it's used all the time. When I didn't look at myself that way. I was a student in class, and I was an athlete when I was on the court. I didn't. We don't use that term with regard to anybody else in college life. We don't say, yes, the student thespian in the back. Well, you have a question. We don't do that. And it's okay for students to pursue other interests. But this is a multi-billion-dollar business. It's a commercial enterprise. It is not amateur. The only thing amateur that I know of in America is golf. And amateur golfers decide when they practice, if they practice, and they decide if they're going to play. I can promise you, when I was here, I did not determine when I practiced. Nor did I determine the volume of practice. But we were essentially professionals. And that's okay, because you can be a professional athlete and be a student. And you know how I know that? Because it's been proven. There are professional baseball players that currently play, and have for years, college sports. They play, paid professional baseball players play college football and college basketball right now. And nobody says a word. Nobody says, get those dirty professionals away from my amateurs. It's legal. Nobody says a word. Trajan Langdon was a professional baseball player while he was here. Nobody said a word. Nobody said, well, yeah, it's antithetical to what college sports are all about. Keep him away from our amateurs. He might infect them with his professionalism. That was never said. But if we allow the players, if we allow them to take advantage of their commercial opportunities outside of school, that's a no-no. Then we're on the slippery slope. God forbid we'd be carrying Pandora's box down this slippery slope. What would happen? Because if we allowed them commercial opportunities, then somebody says, it's kind of like the rule that you can't give a kid more than a bagel in the morning. If you gave him more than a bagel, then somebody would give him a bagel shop. It goes to this crazy doomsday scenario stuff. And that's not the way. The free market works just fine for the rest of us. And we act like it wouldn't work for college athletes, and it would. And this will be the last thing I say on this. If we had a free market system tomorrow, and Coach K could go recruit Jabari Parker, and Duke could provide Jabari Parker with whatever they wanted, the natural and probable consequence of that is they'd insist on a contract. And they'd say, Jabari, we think you'd be terrific here at Duke. we're willing to offer you a contract, but we're going to offer you a 3-year deal. Here are the terms of it. Here's the money. Here's the scholarship. Here's all that. But we're going to insist on a non-compete clause, a behavioral clause, and a performance clause academically. Now, if I'm on Jabari Parker's side, you're going to say, how about 2 years? We'll go 2. And on the academic performance, we want independent reviews so that you can't say he's not good enough, we're going to dump him. And all of a sudden he magically flunks out. You know, you'd have that. It'd be normal business. And they do just fine. Because right now it's amazing how when we're capped at a scholarship, how they can go in and they can say, here's what you're going to be getting from us. And here's what we can do essentially on the side for you. Here are our alums that we can help you out with. Here's this. We can do all that stuff, and it's no problem. It wouldn't be, and we would have all the same complaints that we have now. And the thing that I've always objected to is, let's be honest, it happens here. Our one-and-dones are good kids that have a wonderful opportunity ahead of them. Your one-and-dones are a threat to the integrity of this process. And the truth is, we recruited their one-and-dones too. We didn't get them. We got this one. And what everybody will say is, we'd never take that kid. Okay, you don't have them. You don't have to worry about it. What you're really saying is, we don't want to play against that kid.
Okay,
and I got a problem with that.
Okay. I'll give you guys 30 seconds each to respond.
Rebuttal.
If you would like it, and if not, we'll throw it open to...
You know, I can't respond to everything Jay said, nor would I do it with such good humor. I will say one thing you said that really resonated is the student-athlete term, because I worked at the NCAA for 9 years, and so believe me, it was beat over my head. Student-athlete with the hyphen, because they have to be linked. And it's kind of refreshing. It's almost like you're justifying the model all the time because it's under challenge. It is refreshing to be at a place like the Ivy League where athlete is used as a word when talking about our student athletes. And it's okay because we know they're students when they're in class. And so, yeah, when they're with their team, they're an athlete, and that's okay too. So I think your point's very valid there, and it'd be great if we could accept that model for the overall enterprise. My 30 seconds?
Yeah, 30 seconds.
Yeah, we're picking on the NCAA a lot, so I feel bad. So I'm going to pick on all professional sports leagues, not just the NCAA. And it's not just the NCAA who makes the argument that if we change the rules we have now, the league, the enterprise will no longer exist. Since the beginning of organized sports, every league has made that when we've tried to make some change. Think about Major League Baseball. If we got rid of the reserve clause, Major League Baseball would no longer exist. Major League Baseball seems to be doing just fine. It's about to be a $10 billion industry. Players are making a heck of a lot of money, but so are the owners. Same thing about tennis. They thought if we allow professionals to play tennis, it's a gentleman's game. If we allow these mercenaries to come in who are making money, it will destroy tennis. Same thing with rugby. Same thing with the Olympic model. And yet they have managed to survive this horrible, horrible parade of, again, that Pandora's box on the slippery slope. It may be a slippery slope, but you can build a ledge. I mean, there are ways that you can stop. There are things that you can do to say, all right, we're going to have limitations on compensation. That's what we have in all the professional sports league. What's missing in the NCAA is that the student athletes have no voice, much less a vote. They don't have a voice. And I think the hope that comes out of this, whether it's through unionization or something else, is that they will have some input in the rules that apply to them, which they just don't have right now.
And the slippery slope doesn't apply to anybody else. It's not coach's salary, there's no slope. Right. Facility spending, there's no slope. The amount of money that we're selling this 9 o'clock games on a weeknight, no slope there. Some people think that the 9 o'clock games, that the networks are driving that. Well, in essence, we are. We're saying, well, we want the game on at 9 o'clock. We'll pay you more to put it on at 9. If you put it on at 7, we're going to pay you less. So whose decision is that? It's the school. It's the school saying, no, we'll take the money. We'll put it on at 9. That's what's happened.
Paul, you want to?
Yeah. The one thing I would say is we're going to have some system of control on the competition, whether the system is the market, whether we're going to have regulation at a different level, geographically, size of program, level of specificity. Regulation will come in because competition will drive excess, and we have seen it in a variety of situations. Since Dean Levy is here, his own University of Chicago sent its baseball team to Japan for 5 months in an effort to promote the University of Chicago. Those students were not in class, and that was something that the rest of the competitors thought was unacceptable. We're going to get some kind of limitation. How legitimate it'll be, where the source of legitimacy will come from, I think is the real question.
Okay, we'll take your questions now. Yes.
I'm interested in hearing from Jay in particular, but the other members of the panel on following up to what Paul just said on, if you were to open up compensation to the players, what sort of restrictions ought there be on recruitment in particular? You know, it seems undoubtedly in the NCAA that the vast majority of infractions by the schools are on recruitment infractions. And there's still a question, you know, do you really want schools to start throwing these huge packages and be negotiating with these 15 and 16-year-old kids in high school from academic institutions, you know, whether they're, you know, not, you know, always the most compliant on the regular rules. So if we were in the system you envision, Jay, and maybe a reaction from the others, what kind of guardrails or parameters would there be on recruitment, if any, if you were to open it up?
I would start with none and then go from there. I don't think you regulate from not allowing anything and allow what you can do to trickle out. I think you start with do what you want to do, and if there are competitive balance reasons we need to make reasonable regulation, that's fine. But most of the things I think you're talking about, you know, when you talk about recruiting violations, have to do with things that don't need to be nor should be regulated, like how many phone calls you can make. Who cares how many phone calls you can make? It's a wonderful exercise, if you're ever interested, to go back and look at the NCAA's regulations on stationery. It's laughable. How many colors you can have, whether it can fold over, whether it can be raised lettering and all that stuff. The University of Maryland had an NCAA violation because you could only have 3 colors for a time on your stationery, and there were four colors in the state seal. And you know, somebody made a mistake, and you know, all of a sudden, because that's the difference between choosing Maryland and another school. You know, all those regulations don't need to be in the rule book. And so I would start with nothing and go from there.
Anybody else quick?
So the recruiting rules I would revise a lot because Jay's absolutely right. There's a lot of crazy recruiting rules. That was the first bylaw I learned back when I was a law student interning in the athletic department. I had to write the recruiting rules in English so the coaches could take a test on them. And they're crazy. And it's because the coaches don't trust each other, and they also want to be saved from themselves because they put these restrictions on because if you don't say the paper can only be 8.5 by 11, then maybe Carolina will create this great flyer that'll be big, and then Duke has to compete with that, and Duke doesn't want to, so you set these crazy restrictions. So yes, we could fix a lot of recruiting rules. I think one of the concerns about a free market bidding process for the athletes is recruiting, and it's where do you put the limits? I'm for one, am supportive of going to a cost of attendance-based system for a scholarship because that's academically tied to their expenses to attend the university they're attending. When you go beyond that, you start to get into true pay for play for the sport they're playing, which is a distinction between the baseball player playing basketball. They're not getting paid for that sport. Maybe a distinction without meaning to some, but to others that's fundamental. I think the concern gets to, frankly, how much are you bidding beyond the cost of attendance, and who is providing that money? Is it the car dealership down the street, and are the car dealerships in Durham going to give as much to the Duke players as they do to the NC State or Carolina players? And then what about Tuscaloosa when it's the only game in town? What are they going to be giving? So I think, as Paul said, that you're going to have some regulations, or the model of having some sort of competitive equity just falls apart, or fair competition really falls apart.
I just want to highlight one thing in Steve's question. Why would we need to negotiate with a 15 or 16-year-old? Well, we would need to negotiate with them because they're not allowed to be represented. I think that's one of the things that really does need to be brought into question, whether the folks in this room shouldn't be given the authority to help represent these kids and advise and negotiate for them.
There's one other issue here. Under the current law, if we allow a regulated form of competition so that the student athletes, the college athletes, the athletes are getting more than just their expenses, above cost of attendance, and then we try to cap that some way and say, well, there's going to be a cap on spending for college football players or for a college football program, whatever it might be, then you run the risk of an antitrust attack. Because right now they're getting protected because it's capped at cost of attendance. And so the Seventh Circuit says that means they're unpaid and you can do whatever you want. Once you go over that, any limitation might run afoul of antitrust law. So short of a congressional exemption or the courts changing the way they're thinking, you have another antitrust issue that might pop up out of this.
Question? Yes.
Jay, maybe for you. In 1956 or 57, the NBA would not recognize the players. And at an all-star game, Bob Cousy and a few of the players refused to have the guys come out of the locker room until they were allowed to be recognized. I say that only because how close do you think that is to maybe happening in a bowl game or a Final Four?
Right here. It's right there. It was talked about this year. It's been talked about. And the players are becoming more aware of their leverage. I do believe, and I've talked about this before, that the facilities that we've built are going to be a vehicle for that kind of protest. I don't think it necessarily has to happen at the Final Four, which brings with it a tremendous amount of risk and burden for the players that do that, or that were to attempt that. We actually talked about this beforehand. I've said before that just the situation we've got here at Duke with a beautiful practice facility that's attached to Cameron. If the players came out for a regular season game and came out to center court and shook hands in front of the Cameron crazies and the referees were about to throw the ball up and they said, come on, let's go play in the K Center. And they walked 100 yards. There's a scoreboard in there. The manager's going to have it all set up. What are we going to do? Would the ADs of the two schools order the players to play on the court in Cameron? Because they could say, hey, you've told us this is an avocation. It's just for fun. We're ready to play. The game's going to count. The officials are here. We want to play in here. We think it'd be more fun in here. And sorry, but we're not party to your little multi-billion-dollar contracts. And so the cameras aren't going to be able to see us, and the paid patrons aren't going to be able to get in there. But that's your problem.
I hope that happens at Carolina so they lose the home court advantage.
But that's going to happen at some point. Now, whether it happens in 5 years, 10 years, the players are becoming more aware. It's just that they're a transient, but they turn over all the time. So it's more difficult to do because you knew Dick DeBenzio real well. We had talked about when we went to the Final Four in 1986, the subject was broached, would you be interested in boycotting? And I said, how about next year, Dick? I'm right with you.
Okay. Okay.
What kind of parameters do you put in place, or do you put parameters in place when there's so much disparity between the revenue that certain institutions make and others don't make, and non-revenue producing sports as opposed to football and basketball?
I would answer that with the question that what parameters do we put on coach salaries, facility spending, and the like? That schools have different institutions have different resources and different tolerance levels. Robin's point about the stationary example was, a good one, but we make a lot of decisions here at Duke, and if we can't decide how big our stationary is going to be, and we all need the NCAA to tell us, we got a lot of problems. And it's funny when it comes to the athletes, we use terms like bidding war. We don't want there to be a bidding war for the athlete. We're not worried about a bidding war for Coach K or for David Cutcliffe or the like. That's just business. And I don't see it that way. I think it would be business with regard to the players too, because they've got tremendous value. And if we don't believe they have value, then what are we worried about? If they've got no value, then they're going to jump at the scholarship, and that'll be the end of it. But I do think they have value, and it's value that they're not realizing and not allowed to realize based upon what I consider to be a cartel restriction.
Gabe, did you want to say?
Yeah, and I think the other aspect of that you hear as an argument against allowing schools to pay their athletes is that it will destroy competitive balance in college sports, and all the best players will go to all the top schools. That's the world we live in right now. All the best players are going to all the best schools. If you ask a college athlete, they had a choice, you can go to Duke to play basketball or go to NC Central to play basketball. They're all going to come to Duke. They do come to Duke. NC Central, the other schools get the ones that we can't
the
fit
top
on our
25 are coming here next year.
Yeah, so it's not going to change. All it's going to change is that those college athletes are now getting money to come here. And it's a more efficient way, I think, to recruit them than figuring out what our stationery should look like or sending them text messages in the middle of the night to show how much you care about them, how much you want them here.
And you've got, I think that a lot of the arguments you hear are if you allow compensation, then T. Boone Pickens is just going to buy the best team every year. All right, well, one, I don't think that's going to happen, but it would be, there are roster limits that could address that. The 5 best quarterbacks are not going to go to the same school because the 4 behind the starter are not just going to sit there and watch the starter play. But the T. Boone Pickens example, one of the reasons I think that's a crazy thing to say is T. Boone Pickens can pay whatever he wants for a coach. There's no restriction on that. And no disrespect to these guys, but he's got Travis Ford and Mike Gundy. He's not paying for Saban or Krzyzewski to go there, or Bill Self or whatever. So, and I don't think Phil Knight is going to be using, Nike's money. I think his shareholders would kind of get upset if there wasn't a return on the investment. I don't think that's going to happen. Business doesn't work that way, and I don't think it would happen.
There's just one other element to this. Throughout the world, professional leagues are between 20 and 30 teams. I think what you would see is the breakdown of the model into some kind of super conference or agglomeration of 30 teams thereabouts that would then insist within their group on certain common rules of competition.
And I think that schools like Duke and schools, and I mean Duke in that I think Duke operates with the interest of all the student athletes in mind, and then other schools that just have a lot of money in athletics would be fine under this model. I think you have to look at the other schools, so we're only talking probably about 60 schools that would be fine in this model. There are other schools that would still be chasing the dream of winning an NCAA basketball game, and they would do that at the sacrifice of other sports. So again, I get back to, if you believe in the collegiate model, then you believe in it for a multitude of sports. And it would be unfortunate to see something that at many schools would lead us down a path of cutting sports. We're starting to see that as it is, and I think that's unfortunate.
And I don't disagree with that, I think, but when we use the term sacrifice, the sacrifice is solely upon the athlete. The athlete is the only one making a sacrifice.
Okay, we're going to promise you we're going to answer quickly and questions. Yes.
This is a quick question. What about the walk-ons on these teams, on the football teams and the basketball teams? So you have probably 90 scholarship athletes, but then the rest of them who are carrying, the bags and doing all the hard work, oftentimes in the practice, will they be compensated as well?
I mean, if it were my choice, it'd be up to the institution. They'd decide how to compensate everybody else. I mean, the coaching staff isn't compensated the exact same way. The head coach makes more than the lowliest assistant, and there aren't fights in the locker room, and it's not a problem. People tend to understand merit-based pay, and I think it would. And we don't have fights over playing time. It's not like the teams break up based upon, wait a minute, the quarterback's on the cover of the program. That's not fair. Put the walk-ons on there. They don't. It's not a problem.
Question? Yes.
How do you think Title IX plays into all this? Because the only 2 revenue sports are all are men's football and men's basketball. So, can the schools pay $1 million to a quarterback and pay a scholarship and maybe some stipend to the NCAA champion golfer? How do you deal with that?
Well, I mean, go ahead, Rob.
No, if you want, you're the...
And part of the answer is, you figure out how much you can afford to pay as part of your budget. And let's say you now have to pay, you have $100,000 you can spend on paying student athletes. You can't spend all $100,000 on the male athletes because under Title IX, let's just say you had to spend half of it on I'm not saying it would work out that way, but let's just say you have to spend half of it. So if you've got $100,000, you can only pay $50,000 to the male athletes. And then you got to pay the other 50 to the female athletes. But every school will be operating under the same.
I actually think that's wrong. I think when you're going to this kind of system, there's no question that these are employees. And now I think we're under Title VI, not under Title IX, so we know you can have differential pay under Title VI, depending on the work.
What is Title VI?
It relates to pay and employment.
Employment discrimination.
Employment discrimination.
I agree with Paul, which is where I think the unionization case, if that goes, I think it, and there's disagreement here about that as well, but I think if you read the decision, it actually is not based on revenue. It's based on control of coaches, student-athlete time demands, and so that applies to women's lacrosse at Northwestern as much as football, in my opinion. So then they become employees too, and at Title IX, I think, is out of the equation. Some women's groups are saying no, Title IX would still apply. I don't know how Title IX applies to an employer-employee relationship.
Well, I think the answer is, so I still agree with myself. That additional compensation doesn't automatically turn them into employees, because the argument right now is they are being compensated. It's just a limit on compensation. So for decades, they haven't been seen as employees. I don't think additional compensation would necessarily magically change that. So,
Joan.
In terms of tax law, I mean, they become employees, and all of a sudden, are you having to give out W-2s and
Yes. And they have to pay taxes on scholarship money that right now is not taxed.
Yeah, right now, it's the discussion is unrelated business income tax, and so far that's not been termed an unrelated business income tax, but for the university. But
Yes, other questions? Yes.
If the right to organize is recognized and upheld and unionization is fed into the system, does that undercut or perhaps kill the price-fixing approach?
not necessarily. It depends on how unionization happens, because in professional sports league, we have a multi-employer bargaining unit. So the 32 NFL teams, for example, negotiate as one with the employees, which provides them with an antitrust exemption from price fixing or anything else. If it's individual bargaining units, so it's the Northwestern football players negotiating with Northwestern as an institution, and then you have the Duke football players negotiating with Duke, and then Duke and Northwestern come together and fix prices, that's still a price fixing violation. Yeah. So it would have to be as part of a multi-employer bargaining unit to get the exemption. So the antitrust issues would still be there even if you have individual unions.
But as far as the current attack in the New Jersey case, where it's alleged that the NCAA is controlling this whole system, they're all price fixing now. Once the right to bargain collectively is recognized, it's an increased competition, or doesn't it introduce competition into the system?
Unless, as Gabe said, it's a multi-employer bargaining unit, and we've got the additional problems that some of these institutions are not under federal labor law. So the majority of them aren't. So unless there were additional changes, the football team is a related not-for-profit corporation or something like that, out from under the control of the state, then I think it would be difficult to organize as a multi-employer bargaining unit.
Michael, you get the last question.
So everybody agrees that the current system is teetering. The question I have is, that's been true since 1924. Everybody knew that this is ultimately going to happen since Sam Massambini punched his fist through his boater after his guy wins at the Olympics, right? And amateurism is on the decline. What's the NCAA going to do? They dithered about this for 3 or 4 years, and they keep saying we're working on it, and some of you have been involved in that. Nothing seems to goose them along fast enough. What can the NCAA do? I mean, maybe that goes to you first, but all of you, I'd be interested.
Well, there are very serious discussions going on at the NCAA level about allowing, and I think there's an understanding at Division I that the programs that are generating the revenue have unique challenges, and this antitrust lawsuit and the pressures on them because of the money, that they do need to have an ability to do more for the athletes, and they should be able to do that if they can afford to. And so we are going to be redesigning our governance structure to allow them to do that, and then the rest of us will have to figure out if we want to follow what they do or not. So I think you are going to be seeing more changes. No one's talking about pay for play, though, in the meetings I'm in. And so the revolution of the system is not upon us. It's trying to do more for student athletes. I do think you'll see that.
It's basically a stopgap. They're trying to stem the tide because we're headed there, I think, to where the athletes are going to be able to be in a bargaining position to get more than just cost of attendance. But the stipend is the level that the NCAA wants to get to in order to be able to say, look what we've done for you. But the same tension is going to exist. I mean, the NCAA will win it in the short run. I think in the long run, because somehow there seems to be this sort of thought that while we've all been chugging down this road of education and this kind of snuck up on us, when the truth is that all these institutions have been chasing after this money for not only for the money's sake, but for also like sports have been used for institutional advancement, and those are great things. But if you there's a thing recently about it's called Requiem for the Big East. It's a 2-hour documentary on the death of the Big East, basically. And it takes you through the entire process of why the Big East was formed and what the teams were selected for, the different schools. They were markets. They were selected for TV markets. And they grew with ESPN and all the goes over all the revenues. 2-hour show, not once was education mentioned. Not once. And it wasn't edited out. And that's okay. Like I'm all for the coaches making as much as they can, and administrators making as much as they can, and these TV contracts, they're great. But the problem you've got is the players are left out of it, and at times they're made to look like criminals. If really we're going to draw the line at a kid getting a tattoo, or like the kids at Carolina with the car. Essentially, a lot of that came down to their use of a car. And you're going, okay, so if they borrow a car and it triggers a 6-month NCAA investigation that costs tons of money. I mean, tons of money. Now, if they had stolen the car, no NCAA investigation. And the school alone decides whether they play. And that's the incentive we have. You're better off stealing the car than borrowing it. And that's, the players see that, and they're gonna, they've been wising up over the years. It'll reach a point where they walk.
Actually, if they had parked legally, there would have been a no.
Yeah.
Okay, we're going to call it quits at that point. For those of you who registered for continuing legal education, there's some materials outside the door that you can pick up. And thank you for coming.